This is another live radio link-up brought to you by the Government Communications GCIS. GCIS. GCIS.
Time's gone 4 minutes after the hour, 6 o'clock, and it's a very good evening to you and welcome to once again another broadcast brought to you by GCIS, that's Government Communications and Information System, on behalf of the Department of Justice. And they're not by themselves this evening. They've got a whole variety of stakeholders that have made this broadcast possible. It's a big thank you to SAPS for having joined them at the National Prosecuting Authority, NPA, Department of Social Development also on board as well, not forgetting the Department of Health, the Department of Basic Education, Correctional Services, the Legal Aid South Africa. They've also came on board, and it's a big thank you to them for having made this one possible. My name is Karabo Lance, and I'm glad to be spending this time with you. Hey, listen, we're going to be adding another hour to this broadcast, so normally we have it for about an hour, but this time around, because we've got two beautiful ladies in the studio, we're going to stretch it all the way up until 8 o'clock, so I'm looking quite forward to that one there. Well, this evening, it's an evening that all parents, children should be listening to, and we're going to be exploring and learning a little bit more about the Child Justice Act. So that's Act number 75 of 2008, and lots of questions really arise as far as the Child Justice Act is concerned. We're talking about questions like issues around the age of the child, and the aim and the role of the Child Justice Act, and so forth, and we're going to be exploring all of that. Many of those questions will be attended to in this broadcast, so don't worry about it. Parents, guardians, teachers, law practitioners, etc., be part of this one here. If you don't, you're going to be missing out on quite a lot of information that we have for you. And unlike many of the programs that we have and the programs that you have already been part of, now this one is going to be slightly different. It's going to be more of a discussion, if anything else, but it's not preventing you as a listener to be calling in. Should you have any questions with regards to what we're talking about this evening, you're more than welcome to call us on our toll-free number. If you're calling from a telecom line, the number is as follows. It's 0800 142 446. The number, as I said, toll free from a landline, 0800 142 446. I've mentioned two beautiful ladies, and here they are. The first one is Miss Osman Pritima, as well as Miss M. Mngati. And joining us by way of telephone, unfortunately, Miss Vuyokazi Ketele Mhlanga could not be joining us due to certain circumstances beyond her control. And these three ladies are going to be chatting to us. It's a very good evening to you. Let's start with you, Vuyokazi. Thank you so much for having taken some time to be with us.
Good evening, and good evening to your listeners and my colleagues there at the studio.
There we go, and a very good evening to you, Ms. Pratima and Ms. Mngati.
Good evening, Karabo, and good evening to all the listeners as well. Good evening.
Before we really go on with our program, let's perhaps just find out exactly what you guys do, the roles that you're playing in your various departments. Let's start with you, Vuyokazi. Maybe you'd like to explain to us the role that you play and what department you're in.
Okay, the role that we have played as NPA in terms of the Act, we are required to develop directives. Those directives are rules and regulations that the prosecutors must follow when they are dealing with children in conflict with the law, and also to come up with training manuals so that we can train prosecutors so that they can be able to deal with children effectively and efficiently. And moreover than that, we have a responsibility of reporting to Parliament on how many numbers do we have for children that have been diverted since this Act came into operation.
Thank you so much, Vuyokazi. Now, what position do you hold at the NPA?
I'm a senior state advocate at the Social Offences and Community Affairs Unit.
There we go. And then let's go on to Ms. Osman Pritima, the position that you hold, and what department are you from?
Okay, Karabo, I work with the Department of Justice and Constitutional Development, and I'm the manager for the implementation of the Child Justice Act, the Children's Courts, as well as the Departmental Drug Master Plan.
Ms. Mngandi with a big smile. She can actually see that I'm going to her, so she's getting ready for me, you see. And the position that you're holding?
Thanks, Karabo. I'm the section head for children and vulnerable groups within the Visible policing area. And basically what we do is develop national instructions, training, and referral networks, particularly with the probation officers, child and youth care centers, and just generally handle children. We're usually the first point.
There we go. So that should really now convince you that we are geared up for your questions. So whatever question that you might be having this evening, we'll be more than ready to be taking your calls at 0800 142 446. We're talking about the Child Justice Act. And a couple of times you'll hear me saying CGA. That's what I mean. The Child Justice Act, the 75 of 2008. So let's get on with it. I'm pretty excited to be doing this broadcast here. We've never done something of this magnitude before, at least that which I'm involved in. So let's go for it and find out a little bit more about the Child Justice Act, number 75 of 2008. Ms. Pratema, tell us about it. What are we looking at here for those people who are not really clued up with regards to the Act?
All right, thanks, Karabo. The Child Justice Act was signed into law on the 7th of May, despite the fact that it was developed during 2008 and even earlier. And it was published then on the 11th of May, and it came into effect on the 1st of April 2010. And the Act seeks to establish a criminal justice system for children under the age of 18, and for those whom we regard as being in conflict with the law. And the Act is also established using the values underpinning the Constitution, and specifically in terms of children, Section 28. And then also is very mindful of our international obligations in terms of children, and especially children in conflict with the law. The Act has very many features which provide specifically for children under the age of 18. In our country, children over the age of 18 are regarded as adults. So children below the age of 18 are catered for in terms of this legislation. So the Act provides for the minimum age of criminal capacity and for children who lack criminal capacity. It deals with very many features such as securing the child's attendance at courts, provides for the assessment of children, provides for other features such as diversions and preliminary inquiries, and also for specific child courts, and then has very specific provisions in terms of the way children are dealt with. I think it's very important that in our history we recognize that children often weren't catered for in very many pieces of legislation, specifically, for instance, around the Criminal Procedure Act. And given our international obligations, we realized, of course, and also in terms of the Constitution, that children need to be dealt with as children, whether they have committed an offense or not. So there's a recognition that children were not treated as children, that our facilities weren't built to deal with children as children. And then this Act comes along and emphasizes the best interests of children and singles out children, even when they're in conflict with the law, for the special protection, so that they have special safeguards which are put in place in terms of this Act. Not to be detained except as a measure of last resort, and that comes out of our conventions on the right of the child. And if then they are detained, that children are detained for the shortest possible period of time, and it's the appropriate period of time.
Yeah.
And then also to be treated in a manner that's appropriate to the age and the understanding of the child. So the measures that are taken must be taken in such a manner that they are kept in conditions which take account of the child's age, the child's sex, to be kept separately from adults, separately between girls and boys, and then also to take account of the developmental needs. So most of these are in line with our international obligations to which we are signatories in terms of all the very many conventions that we have. So it seeks to divert children as well, rather than incarcerating them in prisons. So with the result that we have a system which recognizes that when children are in conflict with the law, there has to be another process that could be utilized where the child acknowledges his or her responsibility in terms of the offence that's been committed. And we'll talk a bit about the process that actually undertakes.
We'll definitely get into that. 14 after 6, time flies when we're dealing with issues of most importance. But now there's something that I'm picking up here, and now one may ask, isn't this act maybe sort of like a scapegoat for kids to go on and misbehave and commit crime and all of that? But Ms. Mngqithi, we're going to come to you just now, but let me take Sipho Chauke calling all the way from Phalaborwa, and we thank you so much, Sipho, for having taken some time to be part of this broadcast. You win the award this evening of being our first caller, Sipho. Good evening to you.
Good evening to you too, Mr. Garov.
What is your question, sir?
My question, I'm not sure if I'm going to put it in the right way, but I hope and believe your guests will understand exactly what I want to know from this question.
Go for it, let's see.
Okay, the issue is that according to what I know, or the way it is, crime is a crime, there is no minor crime.
Mm-hmm.
Why should it be in the case where someone do a crime, like killing somebody, but under a certain age? Because I believe for a crime, is the very same crime.
Mm.
After implementing this law, Child
Justice Act here.
Yes. Then is there any changes in the law now in order to show those cases did the Raukivana or those crimes did the Raukivana and now only decrease the now or there's no change or it's increasing just like that? That's what I want to know.
Ke go leboga gore wena o tsere mogala ga go re letša ga le gore mhlomo go go bolela rena ka sepedi o ka dira jalo nomoro ya rena mogala ke 0800-142-446 o ka bolela rena ka Setswana 0800-142-446. It's a toll-free number if you're calling from a landline. Ungakhuluma nathi ngesizulu mawufuna ukukhuluma isizulu ngiyasizwa ngiyasikhuluma naso isizulu 0800-142-446. Thetha nathi ngesixhosa. I'm going to make my program manager very impressed here. He's got a big smile on his face because I've spoken the language that he understands the most. So do that. Don't miss out on our broadcast this evening. Those are the questions coming from Sipho, and maybe let's jump to a guest on the line and just find out maybe what your take is on this regard. Vuyokazi? Okay, we're going to be chatting to Vuyokazi just now, but maybe Ms. Mngqithi, you want to jump in onto this one and maybe just explain to us with regards to the questions that Sipho had.
Actually, it also deals with the issue of whether this is a soft option that is being employed on children. And it is an issue really that we need to correct that perception that no, when it comes to children, a soft option is taken. No, it's considered just as serious. But what it does is in the assessment that is conducted by the social workers, or rather the probation officers, they're able to determine in terms of the child's understanding. Mm-hmm. If we're talking about a 10-year-old, for instance, their circumstances, their understanding, are they aware of the extent of seriousness of what they have done in actually contributing to the murder of somebody? Mm-hmm. And then take them through the best rehabilitative and developmental process for that child. Mm-hmm. So that the idea being to change the behavior of the child such that they will never again, and they fully understand the wrongness of what they have actually done. So it isn't a soft option because it's an assessment that says, of all these options, is it appropriate for this child who's seen it all, done it all, to actually be taken through a diversion process? Or, given their age and their understanding, as Pritima had indicated earlier, then maybe this child, it would be more appropriate to take them through a court process. Let me just give an example. There was a certain rape case involving, children. Yeah. Having assessed the children and having found that it's actually children who raped each other. Having found that their understanding and appreciation of what had gone through in the preliminary inquiry was such that they understood that what they did was wrong. Then it started opening and paving the way that there may be hope for these children to be rehabilitated through a diversion process. But they were also warned that should they not go through what they need to do in terms of the diversion, then they would immediately go back into the court process and be taken through the full, system of the law. And the same with murder cases, that also happens. You may find that this child, it's more appropriate to take them through the court process and have it operate from that level.
Some of the big words that you mentioned in them, and those are diversion programs, and you mentioning something about processes that are going to be undertaken, assessment reports. We're going to be getting into that just for our listeners to understand exactly what we're talking about. Patko, hold on. I'm coming to you now. You want to add something?
Yes, I'd like to add something to what my colleague has actually said here. I think the caller has raised some very important issues. He's correct when we say we look at a crime and it's a crime. However, there are different levels of seriousness of a crime. So not every crime or offence is a rape case or a murder case. There are other things such as theft out of a car, housebreaking, various forms of crime or offences. And in the Child Justice Act, there are 3 schedules which look at the different levels of crime, and they number from Schedule 1 through to Schedule 3. And depending on the seriousness, those matters are dealt with in a different way. So, for instance, if it's a Schedule 1, which is the least serious matter, then there's a possibility that after assessment, that child will be referred to Vuyokasi's organization, the NPA, with a view to checking whether this is a first-time offense, whether this child is a child that needs to go for diversion, and then the prosecutors can actually recommend a diversion. But as it gets more serious, the child justice kicks in with all its force. It is quite a powerful one. And then just also in regard to that, I think we must bear in mind that this act also sets in place the fact that children below the age of 10 are deemed not to have criminal capacity. So if you are a 10-year-old, a 9-year-old, an 8-year-old, you're deemed not to have criminal capacity, meaning that you don't understand right and wrong, and you're regarded as a very minor child below the age of 10. Then it is the duty of the child to be referred to the Department of Social Development, so that the Social Development and the Children's Courts will deal with that matter. So I think that's a very important fact. There's one other issue that I think we do, and it stems directly from Mr. Chauke's call that I wanted to mention, and that is the issue of what we call QBAC, which is children used by adults to commit crime. And what we have found is, due to the misunderstanding that this is a soft option for children, adults are now utilizing children to crime. But what happens in an instance like that is that the adult is also prosecuted, and severely. And the child will also be dealt with in terms of the Child Justice Act, but the adult will be dealt with in terms of the Criminal Procedure Act.
22 after 6 o'clock. Let's get to you, Patko. You're calling all the way from Eliwell North. Thank you so much for having taking some time to chat to us. What is your question?
Molweni kunjani ba?
Siyaphila kunjani mfowethu?
Yaphila, ngiyabulisa bomama abayi-2 abalapha esibili. Buthi benifuna ukuqonda mina ndiyavuma bathetha nge-justice system. Ndifuna ukuqonda kukho abantwana kufana ukuthi lo mntana lona ne u-under age, let's say una-15 years, and then the meantime kufana ukuthi une-15 years ufana ukuthi wenza an accident yokuthi well uhlaba omnye, and then kufana ukuthi ngokuvulwa i-case kuzothiwa ke ngoku lo mntana lo under age akakwazi ukuthi ke ngoku abe ke ngoku yabantu. Ingaba ke ngoku la crime ayenzileyo ayizubhalwa phansi ukwenzela ukuthi the meantime return pha mhlawumbi kuminyaka 18 iphinde ivuke, ngoba kumaxesha amaningi ngoyibona isenzeka la ukuthi okay ucommitted this crime une-16 years but ngoku iyavuka. Ingaba ke ngoku ibangelwa yintoni leyo? Then umbuzo wami wesibili, ngifuna ukuqonda kwakhona bomama, since ufumana ukuthi well kwixesha elininzi i-justice ibanika i-freedom abantwana abo, ufumana ukuthi no baviolate i-rights zabantu abadala okanye abazali babo. Then ke into endifuna iqonde ukuba kunabantwana abo ufumana ukuthi ngamanye ixesha amaninzi, like let's say this girl pregnant, and then ufumana ukuthi ngoku udampa umntana. Ingaba ke ngoku i-justice system ngeyiphi i-role abathi bayidlale bona kwicala labo ukuqinisekisa ukuthi ezo nto ezinjalo azenzeki? Ndiyabulela kakhulu Karabo, ngizamamela kuTakalani Community Radio.
Ndabulela mfowethu man. Kangalani, you calling from Kala. What is your question, Kangalani?
Okay, but mina into ndifuna uyiqonda mhlekazi wami, ndifuna uqonda uba i-Child Justice Act le ka-2008 yahluka njani na kwi-Children's Charter that was proposed the United Nations. Then umama ebekhe mention issue ye-specific child courts. Ngoku ndizama ubuza uba xa kuthithwa ngezikhothi kuthiwa zezabucala zenzele abantwana zona into enothi zidila nazo specifically zidila neziphi izinto, because ixesha elinje siva into njengoma-Child Abuse Act, oma-Child Support Act, nento ezinjengoma-Child Care Act. Ingaba zonke ezi zinto zifolish under this same act?
Ndiyabulela mfethu.
Okay, thank you, boss.
24 after 6 o'clock, 0800 142 446. That's the number to call should you want to be a part of this broadcast this evening. Perhaps with a suggestion, perhaps with a question. You're more than welcome to do that. I haven't forgotten about you, Vuyokazi. Maybe let's bring you in on this one. And maybe let's jump back to the question that was asked by Padco. Criminal records come back to haunt you. But here's a big question now. Somebody's saying that if a child has committed a crime, maybe they were underage at the time of the offense. Now, is that crime going to be recorded? And what will happen when they grow up? Will that criminal record be taken out and be shown to the person that they look, when you were 10 years old, this is what you've done. So therefore you've got a criminal record. How is it dealt with? Vuyokazi? Okay, I think Vuyokazi, we've lost her there for a bit. We'll try to get a hold of her as soon as we can, though. You would like to jump in on that one, Ms. Mngadi?
Yes, and Mbali, please, Karabo.
Oh,
everybody's go. Yeah.
Nyabona, every time you like, ish, you know,
wonkom nyumuntu pritima and so on.
So, feel like a 16 fellow now. Okay.
No, I just want to feel good to work at home.
I think it's a very important one that Ulongujana Upatko is bringing up here, because I think even parents are really they're really concerned about this one here. If my child does something as a minor, will that come back to haunt them?
Could I answer the issue of the criminal records issue? Could I leave it to Upritima?
Okay.
And could I just answer the aspect he was talking about? AOT agabanjwa when umntana ena 15 okanye omunye uzosuke adampe ingane and adedelwe ngoba I think let us correct those perceptions.
Yeah.
Ingane, if you stab somebody, whether under 18 and above 10, then you can be charged for whatever crime that could be. Now, you've stabbed somebody at the age of 15.
Yeah.
Definitely you can be charged.
Okay.
But I think the thing that confuses people is this one. Eyoguti, you are detained at as a last resort. Now, you are released into the care of your parent, unless there are compelling reasons why. When you have to be then kept within a police facility, just as an example.
Yeah.
And Nakona, we can't keep you for longer than 24 hours. That is our mteto wetu. It's 24 hours. Standing orders, zagaponis, but then it is 48 hours in terms of the Constitution. But then you get charged, and then we have to notify probation officer, then does the assessment, and then you go to a preliminary inquiry. Go back. Same story about dumping gun. You can be charged as well. You are charged for that, and then you are dealt with immediately, so that we can deal with your situation so that you don't do it again. Regarding the criminal records expungement and so on, I think Pritima can handle that one.
Look, the process in terms...
Pritima, maybe before you jump in,
yes.
I don't want to keep Tato holding for a bit longer. Let me take Tato's question, and we'll jump back to your explanation there. Tato, good evening to you, calling all the way from Rhodoport.
Good evening.
What is your question, Tato?
Good evening, Karabo. I just want to ask, in terms of, these young children, especially the ones that are, I'm just thinking of a child who's 10 years old, who's committed a serious crime. How are these children's psychological well-being taken care of? I can only imagine the trauma that they go through. What is the department doing just to make sure that they are, the trauma is not, does not damage them for the rest of their lives? Because I can only imagine how traumatic it is.
Tato, is this now the trauma that you're talking about? Is it the trauma of being detained? If I can, I'm not sure if I'm using the right word.
Yes, I'm just talking about the process that your guest just spoke about now in the studio, going through all.
All right, I think we got that. I think it's the trauma of being detained, not necessarily the crime itself, if I'm not mistaken. All right, we'll go back to that one, Tato. Thank you so much. I think your battery is gone. Thank you so much that you've given us a call, and thank you so much, Vuyagazi. You're back on the line. I see that we're definitely going to be engaging with you soon. So hang in there. There are a couple of questions that I would like you to ask to answer. Really, you were explaining, Pratima, with regards to that follow-up question.
Yes, I think what's important to know is to understand the process in terms of the Child Justice Act. Mm-hmm. For instance, if a child is apprehended for having committed an offence, one of the first things that happens is that the police will need to establish what the child's age is. Because the moment the child is found to be below the age of 10, a different process kicks in. And we'll talk about that in terms of Tato's question from Roodepoort. Mm-hmm. But if the child is found to be above the age of 10, then it's up to the police to charge that child with an offence and call on the probation officers to do an assessment of the child. Mm-hmm. Now, that's a critical part of the process of the Child Justice Act, because that process done by the probation officers under the Department of Social Development then will give us the information in terms of the child itself. In other words, how old he is or she is, what the home circumstances might be, whether he's been schooling or she's been schooling, whether the child's living on the streets or something like that. So that's all part of the background information, and it's done in a very detailed way, because that information is critical for the next phases of the Child Justice Act. So if the child was charged with an offence at the age of, say, 15, and in terms of the probation officer's assessment was found to be the first offence, for instance, and then the probation officer and SAPS will then see to it that the next step is that the child gets taken to the courts. There, the prosecutor will be the first link with the child in terms of the offence. So there, the prosecutor will then examine this charge sheet as well as the assessment report in order to determine whether this is a child who's a repeat offender, whether there are other crimes that the child has been convicted of or whatever, and then refer the child, if it's not a serious crime. The stabbing is a serious one. If it's not a serious one, like it's a theft of a loaf of bread, for instance, then the prosecutor has the opportunity to divert that child instead of going through the entire process of the preliminary inquiry and a trial. Then that child will be given a program that the child needs to follow. And if the child complies, there will be a report back in respect of that diversion, which then means that the child's process, child justice process, is complete. That record is fed back to the criminal record section. And that means that the case is closed, there's no criminal record. So in the case of that 15-year-old who was sent on a diversion program, has completed that program successfully, then you'll find that the child will not have a criminal record. I would suggest that my colleague Vuyo also comes in and talks a bit about where the child is not successful and what the next processes would be.
Vuyo, maybe let's jump into that one there. So if the child is not successful with regards to the program being given to them to, if I may say, rehabilitate, hopefully I'm using the right word here, what happens there going forth?
When the child did not comply with the diversion order and the diversion program, what happens? The child is brought back to the normal criminal justice system. It means that the child will go through trial processes where a child will be asked the question, where we are trying to prove that indeed the child has committed this offense. After the trial process has finished, we can even consider diversion at that point in time again, when we see that the child is acknowledging responsibility, when the child is meeting the requirements of diversion. We can still divert a child before a prosecutor closes its case we can divert there. But if we are not satisfied about the requirements of diversion, we proceed. The child is convicted and sentenced. But what is nice about this piece of legislation is that even at sentencing stage, we can consider diversion program as an option of a sentence, like community-based sentence, when a magistrate is saying that, okay, you are convicted with this particular offense and therefore we are sentencing you to a community-based sentence, that particular magistrate can even utilize a diversion program for this particular child. What we are trying to do is to make sure that the child does not get into these criminal justice processes. But then if the child is not complying, they go back to the trial process. Then we deal them there at the trial process. The normal trial processes, they proceed there.
Mm-hmm. All right. There's a statement: children should not be seen but heard. Am I correct?
I think that's the correct
Well, I
statement.
wonder if that's correct. Well, we're going to be hearing from them coming up later, so make sure that you don't move an inch from your radio. We're going to be hearing about some of the children and what they have to say and some of the difficulties and challenges that they're experiencing. Niva, if I'm not mistaken, hopefully I'm pronouncing your name correctly. You're calling all the way from Uppington. Good evening to you.
Good evening, Karavan. Good evening to the guests at the studio. It's Meza from Radio Riverside in Uppington.
Good evening.
And I just love your enthusiastic approach to to where you're calling from and the radio station that you're listening. And thank you so much to that radio station that you're listening to for having taken this broadcast this evening. What is your question, Neva?
Thank you, Karabo. My question is, there are children that have been used to commit crime in the community. How does the Justice Department handle their cases, especially those who are staying in the streets?
All right, you've mentioned something there. Those who are living on the streets. There's a key word there. So look out for that. It's coming up later. We're going to be discussing some of the issues with children living on the streets. Would you like to answer that one then, Bali?
Yebo. Never. Whilst I'm answering your question, could I also link it to what Kangelani was indicating earlier on? Because now, really, you are talking about children in need of care and protection. And we have a way and instructions on how to handle such children. If I could just refer back to what Pritima has already indicated. The adult who is using a child to commit a crime, let us say, for instance, because the child is small, they can fit into small spaces and assist in a burglary, this adult will be charged with a burglary, forcing, breaking and entering, and in addition, he will have or she will have to answer a charge on using a child to commit a crime.
Even though they were not hands-on, even though they did not exactly go there themselves.
Yes.
Even if, because they planned it all, they planned the execution and so on and so forth, and may have threatened the child, adults. So that becomes the double
charge almost.
Charge that you automatically do. So really it's not to be recommended for adults to try and utilize children. Now, children staying on streets tend to be children that we are encouraging our members to always see them as children in need of care and protection. And the idea is that these children are to be taken and handed over to social workers, social services. We have a list of available social workers. We try also encourage that people have service level agreements so that if I come across a child outside McDonald's at 12 in the evening on a Friday night, I at least would know who to contact and who to hand that child over to. Of course, we'd have to have some order of alternative care that we would need to process. But in an emergency situation, as in the child, no fixed address.
Oh, beg your pardon about that. It's a caller. Stand by, Babu Msweli says, "Aguwe bab, ungabo suga lapho khona." We're just dealing with this matter, and once we're done, we're coming to a babam. So hang in there.
Okay, bab.
Aye, mbonge bab. Which means then what our members are also sensitized to this issue, not only through the national instruction, But also, there's the vulnerable children training that we have, just to take the child, hand over, so that the child can then be properly handled by the social workers, which also links to the issue Tato was referring to, trauma. How do you deal with the trauma that the child experiences? Again, social workers would be trained to deal with that psychological counseling issues, dealing with the child, and getting them calmed and back into a situation where they can be productive members of the community.
0800 142 446. That's the number to dial should you want to be chatting to us. We got the three ladies here, and the two of them are in the studio. One is joining us by way of telephone. Thank you so much, Pratima, for having taken some time. Thank you so much, Mbali, and not forgetting you, Vuyokazi, by way of telephone. Thank you so much, guys. I really appreciate it. Babu Msweli, and let's take your question, and after that, we're going to be going to Balekile, holding on all the way from the Free State. Hang in there. We're coming to you now. Babu Msweli. Gunjan, Bab. I said, but we're not going to talk about that now.
I say,
Osweg.
Akubingelele Karabo bese ngibingelele ikhambeli zethu ezikhona ngibingelela abalaleli bomsakazo ikhona FM ikakhulukazi nawo bonke nje abalaleli bama-community radio abambe iqhaza lolu hlelo olubaluleke kangaka baba khona lapha engithanda ukusala khona kancane ngiyazi ihambeli zethu uma ziyichaza khona lapha engifisa ukucacisela khona kancane ukuthi-ke ama-stakeholders njengoba ikhambeli zibe zikhona iminyango lethintekile ekakhulukazi esebenza ngayo zemthetho nama-social worker njalo ukuthi-ke iluphi uhlelo abanalo lokudila ne-victim ukuthi-ke nayo ikwazi ukuthi is-understand lesimo noma ikwazi ukuthi samukele lesimo ikakhulukazi singaphansi kwalo mthetho lo we-Child Justice Act. So ngifuna nje ukuthola ngaphansi kwalo ukuthi-ke i-victim yona-ke itholaka noma badila kanjani nayo lesimo lesi.
Ngiyabonga baba. Osway. Balekile, all the way from the Free State. Balekile, what is your question? Good evening to you.
Good evening, sir. My question is, are there any child justice center in the state? And my second question is, you guys teach people about this child act? Is it like having some campaigns?
Okay, Balekile, I'm battling to hear you.
Sorry?
Can you speak a little bit louder for me? I'm just battling to hear you in the studio. Can you speak a little bit louder for me, babe?
Okay, my first question is, are there any child justice center in the state?
Where about?
Sorry?
In the Free State.
Okay, in the Free State. In the Free State. All right.
Yes, my second question is, are you guys these people about this child act? Is it like having some campaigns?
All right, 100%. I think I get you clearly there. Thank you so much, Balekile, for your call. Very important questions that you're asking there. 18 before 7 o'clock, 0800 142 446. Babu Msweli wants to find out now, are there any special programs? We're dealing with the offenders here. And for the past 40 or odd minutes, we've been talking about the offenders, whether they be minors or not. But that's what we've been concentrating on. Very important question. How does the victims... Are there any programs that are there to help them that are according with the Child Justice Act?
May I try that? That's a very good question. I want to thank Baba for that question. The first thing that I want to emphasize in regard to the Child Justice Act is that it's a very inter-sectoral act. That means that we have about 9 different departments that work together to bring services both to victims and to perpetrators. So in regard to the Child Justice Act itself, it was realized that we could not deal with the issue of children and criminality by ourselves as justice. This had to be done including all departments and all different organizations, even NGOs in this, who provide very, 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 very critical services so that we can provide these services to both the children and the victims. So in terms of the victims, we must recall that the children and any other victim is protected in terms of the Victims' Charter. Part of the process also requires that, for instance, the victim a statement will be done by the victim in regard to the harm that's been suffered, whether how they were harmed, whether windows were broken, whether they got hurt, or whatever. That is prepared by the probation officer, and then it is tendered to the court in order to assist in regard to the sentencing of the child. So that's the kind of opportunity that's offered to the victim in order to be able to say something in regard to the harm that they've suffered. But then the other processes that the Child Justice Act stipulates are more of the restorative justice options, for instance. So where, for instance, we would sit as the victims as well as the perpetrators and sit together and try and find out what the harm is, that was caused, with how the perpetrator now feels about the fact that there was an offence, and what sort of agreement they're going to come to. Also, in terms of community options that may be offered, you'll also find that the victim will be able to say, I want you, if for instance, let's say I broke a shop window and I'm the 15-year-old child, I can then say, I'm very sorry, I won't do it again, I don't know what to do, I don't earn money. So the shopkeeper would say, I want you to come and clean my shop for 4 months. And that could also be considered as part of the victim's option to restore the situation. So there are different ways of approaching it. And so there are options even available to victims, yes.
All right. 0800 142 446. That's the number to dial there. Children's Charter. That was another question that was asked by Ulongjan Ukangela. Kangela wanted to know the differences between, and we're going to come back to, I see you want to explain something more.
Yes.
But I've just picked up here that Kangelani will probably be upset with me because there was one question of his that we did not answer here. And is that whole, the relations between the Children's Charter that was brought in by the United Nations, that with regards to the Child Justice Act. What are there any differences? Are there any similarities?
Okay. The conventions and the treaties which are produced by the United Nations, and South Africa's become signatories to many of those. They need, in terms of becoming signatories for us now as a country, as a state country, is to first of all start incorporating whatever it is that we've taken the obligations of into domestic legislation, which means that we must develop acts in terms of South African law, setting out those obligations in terms of what we will do in terms of our law. So one of those, for instance, is the United Nations Children's Charter, or the rights of the child. Mm-hmm. And part of those are the issues around children's interests being held uppermost in every matter that concerns the child. Mm-hmm. Where children have committed offences, that they be dealt with in not more severely than adults, mm-hmm. and that they are dealt with in such a way that their age and the circumstances are taken into consideration. And you'll find that when you read the Child Justice Act, you'll find many of those conditions are incorporated. And similarly with our Constitution, which forms the basis of the way we deal with people in South Africa, you'll find that we have incorporated whatever the United Nations conventions and the African charters might say. We've incorporated that into our law. Mm-hmm. And in terms of the minimum standards for prisoners, for instance, we've also incorporated what is needed from us in terms of the Child Justice Act and for the way children are dealt with.
Mm-hmm. Kangelani, you on the line?
Yeah, ndikumamele futhi.
Thatha mfundini.
Oh, okay, ngiyakuva futhi no ungiphendulile. Enye into ke ngobe ngifuna uyibuza futhi wami ingelo umcimbi bekhe wamention the issue of a specific child court. Benifuna ukhe nje unbrief nje just to highlight ba kanye ezikhothi zeziphi mhlambe ezona zinto zidila nazo that revolves around abantwana. To be specific, kulezi child court, this is what we deal with in A, B and C under these circumstances ezithile.
100%. Thank you so much there, Kangelani. We've got Vuyo, who's a dreamer, calling all the way from Begersdorp. It's a very good evening to you, Vuyo.
Hello, Karabo Kunjat.
Ndiyaphila mfethu kunjani?
Ndiphilile nami Karabo. Karabo ndi manibulise nako mama balapha studio ne. nezingomathaveni ngelo xesha abantwana baya bethonyiwe mhlawumbe ingaba ke ngokulonto i-Child Justice Act iyawakhusela na amalungelo wabantwana xa bathe bathuthumbiswa ngamapolisa mhlawumbi amapolisa afuna lo evidence kanye lo mntana atestify kule case kodwa ngokuye yakhe ne but abethe umntana ingaba ke ngoku act lena iwajonga na amalungelo abantwana. Umbuzo wesithathu ndifuna ubuza ke ngoku ukuba umntana usafunda andithi mos i-priority imfundo kulezwekazi loMzantsi Afrika, then the question is if umntana usafunda ke ngoku ingaba i-Child Justice Act like ijonga ngeliphi liso into yokuba umntana xa athe wasentenswa lo minyaka kanye ezo nyanga ukuba imfundo yakhe usilela kangakanani na, because as we all know ukuba ayikho imfundo phakathi etilongweni. Ndifuna nditshekisha nje futhi ngabezondo zijongolo phela nehlomza mamele unique.
Ndiyabulela mfowethu. Nonkululeko, you're calling all the way from Uppington. Don't worry there, Vuyo Ulongjan Usisimbali will definitely answer your questions. She's got them all noted down and she's read. She's read. Nkululeko, you're calling from Uppington.
Good evening, sir.
How are you doing?
I'm fine, thank you. And yourself?
I'm very well, thank you so much for calling in. What's your question?
A pleasure. I actually have two questions. The first one is I'd like to know what the aim of the Child Justice System of 2008 is, or the Child Justice Act.
All right, that's
what
your first.
The aim is.
Okay, is it your first one?
Yes,
your second one?
Yes, and the second one, I'd like to know what the relationship between the Justice Department, the NPA, the SAPS, Correctional Services, the Social Development, and the Legal Aid Board have with the Child Justice Act of 2008.
Thank you so much, Nkululeko. And as I said from the beginning of the broadcast, thank you so much to the following stakeholders in collaboration with the Department of Justice, South African Police Services. They came on board, National Prosecuting Authority. They're also part of this broadcast. The Department of Social Development, Department of Health, the Department of Basic Education, the Correctional Services guys also said, hey, we're not going to be left behind. We're going to be riding this one with you, and the Legal Aid of South Africa. These are the stakeholders. How are they relating? You're going to be finding out. So hang in there. We're going to definitely tell you in Gulego. And we're going to be finding out a little bit about some of the challenges that the street, I don't want to call them street kids, but let's call them children living on the streets. I think that's the appropriate term to use this evening. We're going to be finding out a little bit about some of the challenges they have. Let's go for it and check out what's happening around there.
Any of you, if you are arrested, why were you arrested? Were your rights read to you? Did you know your rights?
Salega tswara ma ka me ya ka me ka 24 bangara mo sturuweni mo la ke tsama ba fitha ba ema mo la ba researcha ba so searcha ba kreselo kan bona ba tshwere patsi mo la ba re nna ke la tlile patsi mo fatshe. Then banti ya bankisa police station nele satarata yar sonta mantare ya koto ba fita ba re 60 days in prison or 1,000 bay na ga ba botsa gara ke bereki a ke ne chelete re nga bila ga yona ba re se tsala ngwena re tshwere ka patsi ke re na batho ba le bankerele isne selo ente ba mpointa ka ntho ke sa ira mo bana ke at the end they felt like a full tracker go spantiti kana die 2 months ke sa ira se.
Is there someone who wants to say something about that?
Yeah, na bothata bo teng ka maphodisa go tshwariwa ba ntshwere ka June. So ka mko ba ntshwere mara June ba na le nna ba ntshwere ka patsi le re patsi ne sa tsubi ke nna ne tsuba ke tshomya ka bese. So tshomya ka mkhorela a tshaba maphodisa a tlhaela ba salan ba ntshwere ka patsi le sino ba ntshwere ka patsi la lephodisa le tsang le lwa le nna ne le bushio he le lwa le nna ba le thapisa dikobo tsaka welo thapisa dikobo ka motlohela sharp o ya le nna police station o fitla police station a sige mmonte le sefane ta mano o ngwa le sefane sa ga ke tshabalala hayebo so right ka mmota ke re nna sefane sa ga se tshabalala sefane sa ga e tsulo ta mano ha no cancela tshabalala sharp ka usani wa khoto ku khoto kwa le ba re nna ngwa di sete di fane tsa maka ba mphanisheta ta itena re sefane sa ga ke tshabalala and then sefane sa ga sa nnete ke tsulo ba etsa ba mfa 2 months in prison ba nkisa ga popotjana. So in that 2 months ke ntse ke complain ka yona ntho ha ona maphodisa na itse re ntabe ya response wa se sa ga eng bona ba no mpotsa se sala go tshwera.
800-142-446. Those are some of the voices of the children that are living on the streets, some of the challenges that they are facing. One of them has mentioned that he was arrested while he was just walking about at night, and he was searched, even rights not read. He was searched, and he did not have anything on him, as the police would have thought maybe he had. But one of the things that he's mentioned is that dagga was planted in his pockets. And they've mentioned that they're arresting him for possession of an illegal substance. And another one came on and said he did not commit the crime of smoking dagga, but his friends were doing that, but he was arrested in 10. And in addition of that, when he went to the police station, the police insisted on writing a wrong surname on the statement. He insisted that the surname is incorrect, but they had proceeded to write an incorrect surname, thus resulting in the court fining him or charging him with, I would say, incorrect statement given, if I'm using the correct terms. So these are some of the challenges that really the kids are facing, the kids living on the streets are facing. What is our take on it? And I think, Vuyokazi, you've been holding on for a bit too long. Let's bring you in on this one here. Maybe you can understand, maybe you can bring us up to speed in terms of some of these challenges here. The rights of kids while being arrested. What rights do they have? What is it that they can insist on when the arrest is taking place as far as their rights are concerned?
The rights that they have are the rights that anyone that has committed crime has. For example, one of the rights is that a child has a right to legal representation. So a child can insist that before I can say anything, before I can move forward, I need my lawyer. And the state has a responsibility when the child cannot afford that particular lawyer. A state has a responsibility to appoint a lawyer on behalf of that particular child so that that lawyer can assist that child. In the event where a child is saying, I don't need a lawyer, I'm going to proceed myself with this particular matter, the Child Justice Act always insists that there is no way that the child cannot be assisted by a legal representation. So if the child is saying that I don't need a person in terms of that right, a magistrate or a child justice court can appoint a legal representative from Legal Aid South Africa to assist the court, irrespective where the child is saying that I don't need any lawyer to assist me. So that is one of the rights that is incorporated in the Child Justice Act. So that child, even if the child is saying that I don't need a legal representative in this particular matter, I'm going to proceed myself. Child Justice Act insists that there must be a legal representative at that particular court. But one person will ask a question, but if a child is saying I don't need any person to assist me, why the court will appoint a person? A court will appoint that particular person to assist the court. You will understand that at court there are issues of cross-examination, issues of objections, and issues of sentencing. That child doesn't know anything about law. If the court is saying to that child, okay, address the court on sentencing, that child will not know anything. Therefore, the person who is a legal rep from Legal Aid South Africa, who is assisting the court, taking into consideration best interest of the child, will be able to assist the court with the sentencing option, even questions of clarity, because the child at court will not be able to ask questions of clarity, because we also agree with me that children are very scared of court settings, so they don't know what to ask and what not to ask. So that is one of the rights that is coming out clearly in the Child Justice Act, a legal right, a right to remain silent, a right to be offered information, what is going to be happening with this particular matter. And maybe to go to the one question that has been asked, what are we giving victims in terms of this particular act? You know, as prosecutors, our role mainly in terms of this act is to divert children away from the criminal justice system. But that act is saying to us, prosecutor, when you are about to divert a serious matter, for example, to do a rape case or a murder case, please consider the views of a victim. Like if this is a case of a rape, a victim will say to you, for example, will say that you are going to divert this person. I don't have a problem with that, but my problem is that I won't be able to stay with this particular person in the same community because I'm still traumatized with this issue. So those are things that we consider before we can divert children. And maybe also to come to the question that was asked about education, it is very important. When we're about to divert children, we consider those issues. If a child is still at school, we make sure that we divert that particular child to a program that will not disturb that child. Remember that in terms of the act, to child to prison should be a last resort. You should have used the non-custodial sentences, like your community-based sentences, your restorative justice sentences, payment of fine or alternative to that. So we need to utilize that. We consider very much the issue of education. And one of the questions that I've heard from a listener is whether the probation officers do check what was the cause of this crime being committed by this child. That is the main aim of the assessment report, because before, as a prosecutor, I can divert this particular child, I need to get the circumstances of this child, why this child has committed this particular offense, because these offenses, they link to each other. It might happen that a child is committing an offense, is assaulting people outside because there's an assault going on, there's a domestic violence going home at home. So a probation officer's report will assist with regard to that. It might also happen that a child is stealing bread from ShopRite because there is no food at home. Therefore, there and there we can see that this child is in need of care and protection because this child is stealing because there is no bread at home. So that is the main purpose of the probation officer's report. And if we are not getting anything from a probation officer's report, in terms of the act, we have something called a preliminary inquiry. That's where we seek more information. We want to get more clarity before we can even proceed with this particular child. We want to know that if the child is having a criminal capacity or not, because it might happen that a child is committing an offense without understanding the implications thereof, without understanding that a child actually committing an offense. So those are the things that we are looking at. Can I pause there?
So there we go. That's the voice of Vuyokazi Ketele Mhlanga on the line, joining us there to be chatting to us this evening alongside Osis Osman and Osis Pratima rather, and Osis Mbali right here. So if you want to be chatting to them, 0800 142 446. Coming up in the next 3 minutes, we're going to be hearing a clip from the Legal Aid South Africa, what they have to say. So hang in there, that clip is coming up. But let's go to Sis Mbali. Some of the questions that were asked by Ubab Vuyo has been answered briefly by Usis Vuyokazi. Yes. And I think that's those names going in conjunction there. But there are some of the questions that are still outstanding that you would like to tackle there quickly.
Very quickly, I think Vuyokazi umphendule kahle uVuyo. Ukubethwa, the being beaten up. Now, just to say very briefly, you know, all issues relating to torture, beating up, that is definitely not part of the way that our members are supposed to conduct themselves with anybody, whether it's a child, adult, whatever. And I would just urge that people who say they experience such should always ensure that they make that report to the local managers, the station commander, the shift commander. They can actually say, who is in charge? Why do you want him? I want to lay a complaint. And then set the complaint so that it can be dealt with immediately.
3 minutes after 7 o'clock, 0800 142 446, the number to dial. Now we're going to be hearing a clip about one of the children living on the streets with regards to their experiences regarding the Legal Aid of South Africa.
What do you think Legal Aid Board should do for cases like this?
Legal Aid bona skervela ke loyara tsela tsa mmusho so ntse ba re thuse bona mara ntšho ka lebela o irala o khona swariwa maybe a kere ke be ka matho ga o lwa phiera la obedi go khoto ba botsa ro o nyaka loyara mmusho re loyara tšhelete o botsa ra ke nyaka loyara mahala ke bere ke sno ba fa loyara ga o lwa prayer la bo 3 go khoto still 1000 loyara mara ba botsi tso nyaka loyara wa re every time ba o remind mara wena na ntho se bengwe bolela mara o nyakile lawyer mmuso o lebeletse re tla o thusa ke bona ke bone mmereko wa bona ba o ira pila
ba tsa tšhelete ya rona fela lawyer tsa mmuso just statement ba nyaka tšhelete kore tshwentse ba o thuse mo molatong ba botse gore o tshwere kang o ba botse gore nne ke tshwere ka patšhe se mare ke tsela ba re nne 600 fine o ka kgona e ntshana wa e bona o sa ntshe o tshwere ga ona ntho e ba o thusang ga ona no help.
Four minutes after 7 o'clock, this is our special broadcast brought to you by GCIS, Government Communications and Information System, on behalf of the Department of Justice, and they, together with the SAPS, that's the South African Police Services, together with the NPA, National Prosecuting Authority, DSD, Department of Social Development, Department of Health, Department of Basic Education, Correctional Services, and as well as the Legal Aid South Africa, they've made this show possible, giving you information that is very vital to you, and would like to invite you to call in with questions that you might be having this evening. Mahlasela, we're going to be coming to you now in a short while, but before we do that, Pratima, you would like to mention something quickly?
Yes, I wanted to respond a little bit to the question that was posed by Balekile of the Free State. And she mentioned she wanted to know what was the aim of the Act, and then also mentioned all those departments that we work with and what was the reason for that. And that is basic and fundamental to the understanding of the Child Justice Act. So, as I said earlier, when the Child Justice Act was drafted, it was recognized that social problems and criminal issues amongst children have to be dealt with in an intersectoral manner. So you'll find that each of the departments that are involved are contributing to the issue of dealing with criminality amongst children. So that SAPS, for instance, has a specific role in terms of their core business. So they would arrest and charge somebody who's committed an offense. The Department of Social Development gets involved in order to see to it that children are assessed and get the benefit of the programs in terms of diversion. So that's their role. Then the NPA deals with the prosecutor, and so on. We go through. Department of Health will look at the trauma issues and see whether criminal capacity assessments need to be done. Department of Education would deal with the issue of having to continue the child's education. Department of Correctional Services, for instance, right at the beginning when we started with the implementation of the Act, I think we had in the region of above 700 children in prison, and most recently it's been reported as only having 77 children, because there's been a recognition by Department of Correctional Services that prison is not a place for children unless there is nothing else in terms of the sentencing options. The other question that Balekile mentioned was around whether there are any child justice facilities. Yeah. And in the Free State, we have what is known as the One-Stop Child Justice Center, which is located at Mangaung. And it's one of the oldest one-stop child justice centers. And the idea is to provide all the services that a child in conflict with the law would require. So you'll find that SAPS have an office there. The judiciary are also on the premises. Social development is on the premises. LASA is on the premises. So all the parties that are involved in providing services to a child when the child's in conflict with the law are available at the one-stop child justice centers. And maybe when we have a little bit of time, we could talk about the aims of the Act, because that was another question that Balekile had posed.
We're going to definitely jump into that. We still have a bit more time to go. We're going to be wrapping up at 8 o'clock. We've got about 15 minutes to go. But let me not keep you holding for long. Neville, you calling from Bloemfontein. Good evening to you. Good evening to you, Neville. Okay, looks like Neville, you on the line.
Yes.
Good evening to you. How are you doing?
I'm fine. How are you, man?
I'm well, thank you. Neville, what is your question?
Sorry?
What is your question, sir?
Okay, my question is, in case of young people that are detained at a sexual care center, and you find that maybe, they can't deal with, serious cases, right? Go out.
Neville, hold on for me. Are you walking around?
Yes.
Can I ask you to stay in one spot until you finish your question? As you walk about, we're losing signal. Are you still there?
I'm here.
Okay, that didn't sound like a Neville there. Definitely didn't sound like a Neville there. Is this who is this on the line now? Hold on. Neville?
I'm still on the line, Vuyokazi Ketelo.
Okay, Vuyokazi, Bamancane, I still want to tackle Ulongunjan. The question Yaga put Neville Lana from Bloemfontein. I think we had, you see, that's exactly what I was talking about. He was moving about and now we've lost signal. But no worries, our producers are definitely going to get a hold of you as soon as they can. Hey, listen, don't miss out on this evening's broadcast. 0800 142 446. That's the number to dial. 0800 142 446. Oka buela nna ka Setswana ga ile gore batho go bua Setswana kapa oka bolella nna Sepedi ge ile gore nyoko bolela Sepedi, Seswati, Sexhosa. We welcome any language that if we don't understand what you're saying, we'll definitely ask you to translate that in English. But hey, why not ask with any language of your choice? We'll definitely try to assist you to the best of our abilities. There we go. And Pratima, you would like to mention something, and we're going to jump straight to Mbali afterwards.
Okay. Yes, thank you. I wanted to highlight the aims of the Act as was asked by Nonkulelo from Uppington, I think it was, if I pronounced the name correctly. Now, the Act is very specific about what it's trying to do. It says very clearly, it says it's providing a child justice system which caters for children. And then it says they're creating the possibility of diverting children who are in conflict with the law. And also where it's appropriate to see that children are not made part of the formal criminal justice system via the courts. Okay. Then it also wants to expand and entrench the principles of restorative justice, and it also wants the present realities of the country in regard to crime to be recognized. In other words, we're not minimizing the effect that children do actually commit offenses. Yeah. So we deal with crime as crime. Mm-hmm. Then we also want to balance the interests of children and society, which is very important. We want to also place mechanisms, special mechanisms and processes which take into account the past and unduly harsh measures sometimes against children in the past. That's very important for us. We also want to look at the long-term benefits of having a less rigid system. We also want to raise the age of criminal capacity, and we want to look at the individual needs and circumstances of children instead of dealing with them in a globular way.
And there's a whole lot more.
Yes, that's correct.
We're going to come back to that. Neville, you back?
Yes, I'm still holding on.
And now, where's my glass of water? Because you've just gone quickly to get a glass of water, but you don't bring any for us, Neville. That's not the right
I don't
man.
know what was going on because I was driving, but I'm packed now.
Thank you so much, sir. What is your question?
My question is, in terms of the Child Justice Act, young people that are detained in secure care centers, and then where you find, in the case where you find that the young person is detained there, but he's putting the lives of other young people at risk.
Neville, let me ask you to switch off your radio. I can hear it in the background.
My radio is definitely off.
Okay, I could hear two Nevilles there.
Sorry,
so let me
my radio is off.
let me hear the one Neville. Go on, sir.
Okay, my question was in terms of the young people that are detained at the secure care center, and they commit other offenses while they are still in detention, or they put the lives of the other young people at risk. Or maybe let me make a practical example. They commit a Schedule 1 offense while they are in detention, but again, they also put the lives of other young people at risk by forcing them, or say bullying them, or forcing them to join gangsters while they are still exposed to other developmental programs that are meant to assist them. What resort the staff have in terms of asking for alternative placement for the young person?
Thank you so much. Is that all, sir?
Yeah, my second question is,
okay,
in terms of the Children's Act, if there is a court order that places a young person either at a children's home or at a school of industry, if that young person absconds, there is what we call absconders procedure that is opened. What happens then in the case of young people that are in secure care centers that abscond? Do we also go the route of absconders procedure, or what is it that we need to do?
That
is all.
Thank you so much, Neville. Drive safe.
Thank you. Bye.
There we go. Neville, we're going to be coming back to your questions. 13 after 7 o'clock. Mahlasela. Good evening to you, Mahlasela. What is your question?
Ndade.
Levendad.
Ndade.
Punya sele. Bualin.
Ndade ngabota he.
Ehe.
Ndade.
O ka botsa ndate potso ya hao e reng?
Potso ya ka ndate ha o ke la shebi diketsagalo tsena di etsagala bo mapolasing mo batho ba senang bo lesedi le lekalokalo gape mo batho ba ntseng ba ya ka meetlo. So e ka ba tse ke dikotlo di feng tseo batho ba di fuang ba entseng ketso tseo tse soto ka neng. Charity ke yona le potso le
ke a leboha ntate
ngale
ke yona fela potso o nang le yona
ke yona fela ntate.
ke a leboha ntate o mametse radio e feng
ngale
o mametse radio e feng
ntate
ke efe radio o e mametseng
ntate
o ile he ntate ke a leboha for potso ya hao o na le motho a nang le potso hape dumela lebitso la hao ke mang? Charity.
Yes.
Charity, dumela ausaka potso ha o reng?
What are the responsibilities of these organizations in the Child's Act?
Okay, ba tlo e hlalosa hape ba ne ba bua ka yona hona jwale ke na hona mohlomong ha wa utlwa ba tla e hlalosa hape ke leboha mme wa ka gore lwena o re letsitse mohala 15 after 7 o'clock. Yes, you lost track there all of a sudden. I'm looking at my paper and it's written all over. I don't know where to start. Let's start somewhere. You're ready, Bali. Let's start from you, and then I'll work my way through all these questions. And then coming up, we're going to be having a clip. That's one of the child that's living on the streets. He's going to be talking about the impact of social development in their lives. Hang in there. That's all coming up, Mbali.
Could I start with Charity's question?
Let's go for it, yes.
Because for us, children under 10, really it's the Children's Act that is operating. We're treating them as children in need of care and protection. So basically, as the police, what happens, even if the child is involved in some crime, then it is for us to then hand the child over to a social worker who can then do further assessments, determining all these things that Vuyokazi was also talking about, assessing whether the family situation, what is contributing to their dealing with crime, and then processing the child. So in that way, that could be treated as a child who is either neglected in terms of the Children's Act, which could be what is then contributing to them being involved in crime.
Yeah.
So that is really what I can say in that regard.
Can I add something to what Mbali is just saying? I think it's very important. The issue of children, even as we've explained, children who are underage commit crime, but you'll find that sometimes, even where the child is over the age of 10, that child has been neglected to such an extent that child might be also in need of care and protection. And in a situation like that, for instance, you'll find that the probation officer's assessment report will make mention of the circumstances of the child. And when the child is then referred to the prosecutor may find that this is not a child who's committing offences as a result of being willful or knowing that this is a criminal offence, but actually is a child who cannot survive as a result of needing care and protection, and the child would then be referred via the court to the children's court, where this matter will be dealt with further. So the criminal issue will be dealt with further by the children's court. Now, the children's court is different to the child justice courts. The children's courts deal with children who are in need of care and protection, and in terms of the Children's Act, whereas the child justice court deal with children who are in conflict with the law and deal with the criminal issues. So these are two separate courts, and we need to bear that, and two separate acts in effect, and we need to bear that very clearly in mind. Thank you.
18 after 7 o'clock. Let's hear another clip from the same child that we've heard earlier on. But this time around, the impact of social development in their lives. What's their take on it, and how is it affecting their lives? Let's find out quickly what they're saying about that.
Social development. What do you think they should do to assist you guys?
Social development, then another at least Bakaira plan, maybe 2 Savera, by under 18 or 1 or 2 plan or like Basana Pelawa, so
it's not like it's a life that they love living, or it's entertaining to them. It's something that they seriously want out. How can we help them, guys? What is it that you think we can do?
I think we can assist them through public awarenesses, because sometimes they don't even know where to go.
But because we are inter-sectoral, we need to have the same word together to say that this is crime, it is wrong to commit it. But how can we begin to prevent, to come up with preventative measures on how can we prevent crime? So we need to continue with public awareness and public education, because that's very important for me, for them to know that this is crime and where can we get assistance. Because some of them will agree with me here that we're talking about children in urban areas and children in rural areas. And you might find that those that are in rural areas, they don't even know about these services. So I will promote the issue of public awareness and education in this regard.
Mm-hmm. The Children's Justice Act, in collaboration with what I can say, perhaps let's I want to give it the correct term. Really, it's somebody has called in mentioning something about rural areas and their laws. So we're talking about chiefs, in Setswana we're talking about the Khosi.
Yeah.
How do you work in collaboration with them in terms of, I don't want to use the word punishment, it sounds too harsh, but in terms of that?
I think we do need to acknowledge, first of all, that a crime is a crime, and the punishment in effect for crime, as we talk about punishment as in inverted commas here, must be done in terms of the Child Justice Act. The Child Justice Act, what it does is it allows for input, for instance, at a preliminary inquiry from the teacher who may know this child since the child was at school, from the parents, from if there's a church leader or a tribal officer that wants to come and give input in regard to why this child may have committed this offense, then that is also permitted. So all the parties who know the child and who may be able to give information as to why this particular thing happened can come together at this preliminary inquiry and afford that information, so that when the magistrate makes the decision and the court makes the decision, it is made on an informed basis. So I agree fully with my colleague Vuyo that we do need to continue doing these public awareness issues, because the Act works over so many different partners and so many different fields of expertise that it actually does require us to talk a whole lot more about what does the Department of Social Development do, what does SAPS do in this Act, what does the NPA do, what does Justice do, what is the judiciary's role in regard to all of this, so that when a child and a parent, for instance, are confronted with regard to an issue under the Child Justice Act, they understand that all these measures have actually been looked at, and this is the proposed way that they should go, and understand what those rights are that child actually has.
Old school lashing. Ashley, hold on for me. I'm coming to you now. Just give me a couple of seconds. Old school lashing. We're going back now to how things were done back, giving you a couple of lashes. But now, the corporal punishment has been done away with. How now if a tribal officer comes to you and say, they say to you now, look, Tina Lana, we deal with this issue like this. You people from the Justice Department do what you have to do. Magabuya Lana Tina, we're going to give him 5 of the best. What is your reaction to that? Do you think, is this something that's still allowed or not?
My reaction immediately is the Constitution clearly states, let no harm be done in the name of culture. Whatever cultural rights shouldn't then be utilized in such a way that the integrity of somebody else is put in a problem. So there is currently a traditional courts bill that is being discussed, and the whole restorative justice policy issues that they were talking about earlier, which is saying maybe we need to get our traditional leaders and authorities to actually assist us to solve the problem and not be part of the problem. Solve it in a way that at least the victim and the offender feel that their situation, this one is truly sorry, changes their behavior, and the other one continues. But could I just go into this interesting part where suddenly we're moving from the police planting dacha on people to people realizing they need rehabilitation.
Yes. I thought that sparked an interest with you there. I saw that.
It was interesting.
Yeah.
But basically what needed to have happened at that stage was on arrest. They don't say whether that process was done, but on arrest, the probation officer should be informed so that there is an assessment done of this child.
Mm-hmm.
After the assessment of the child, then there's the preliminary inquiry where everybody is there. And then moving from that, then you may have had an option that would have then said, okay, this child needs rehabilitation, link him to Sanka or whoever deals with drug rehabilitation issues. And probably that would have been a better option. But I just found it interesting that suddenly, from being planted with
that we need help.
No, we need Dacha help.
Yeah, but I mean, what about those that really do need help? Which is something that we're going to answer coming up. Definitely, we're going to jump into that, Sisambali. I don't want to keep Ashley holding on for too long. Ashley is calling from all the way from El Dorado Park. It's a very good evening to you, Ashley.
Good evening. Good evening. How are you doing, sir?
I'm very well, and yourself?
Good. Very well, thanks. And good evening to your guests there as well.
Good evening.
Very interesting discussion and very informative as well. My question is the Child Justice Act expressive about the protection of the child's right to education who is in conflict with the law?
Child's right to education for the child that's in conflict with the law provision made by the Act. We're going to be finding out. Thank you so much, Ashley, for your call. And we're jumping to Durka, if I'm not mistaken. Is it Durka from the Free State? Is it Durka?
Hello, Karabo.
Is it Durka?
No, ke Dika.
Dika. O ka ntate? O utlwa Dika ke buile ka sekgowa ntate.
Oh, ke tracker.
Au tlohe ke buile ka re ke deka mona ke nne ke shapa ka sekgowa. Au tlohe ntate wa ka ke nne ke re ke ba bontsenyana hore tse ding a mang a mabitso a nna re ka bua ka sekgowa.
Ya yona ka se le bua ka sekgowa.
Ntate Dika/Durka. Potso ha e re ntate.
No ke le bua Karabo ke Dika from Karabo FM.
Au tlohe.
Ka taba hore na ke eng so all these departments the your correctional service, legal aid board, Department of Justice, SAPS, the NPA. Se ba di etsang to go to the rural areas mo e leng hore fumana hore there are issues about child labor tse ding ka karolo, just to make sure hore ba tla ka di awareness tse tshwanetseng, because dintho tse di ka tla di etsang ka baka la hore our people are actually lacking information mo e leng hore it will not be enough mo e leng hore ho tla ba this kind of a program once mo e leng hore ha re kgone lo ka fitla di bakeng tse ding ba etsa eng collectively to go to those areas mo e leng hore they can be able to address or come up with outreach programs for awareness bakeng la ho taka this kinds of awareness mo di bakeng tsa mahae.
Ke lo mandad
tangina
ke yona potso nona le yona sisivukazi sisam usese khona ungabaleki phela ngisafuna ukuthi uzonginceda lana ngama question. What is your response to the last caller's question with regards to some of the stakeholders with regards to the Children's Justice Act? Do you go out to rural areas and educate people, and have you done that? Is it something that you're looking at doing in the future?
No, we are doing that. We have done it. We are continuing to do that. Together with the Department of Justice, we have a project called Project Ndabezita. That's where we speak with the Chief Inkosi and sensitizing them about these crimes and these issues against children. Because one of the things that has come out clearly, in some of the rural areas, what will happen is that when a person has committed an offense, that particular matter goes to the King's Cross so that it can be tried there, so that they can resolve it. In most cases, what they usually do, like in domestic violence cases, they will say that if a wife, for example, has beaten, if a husband has beaten his wife, they will say that, okay, in terms of our law, you must give us a cow or something to that issue. So we're trying to sensitize them and also to say to them some of the issues they need to get to the court of law. You don't have to try these issues yourself, looking at the seriousness of the offense, one of the serious offenses is the one of ukutwala. You know what they do in our days? Parents, they will negotiate the child to be twalad and everything else, only to find out the child is still under it. The child doesn't know what is getting into and so forth. So that's what we are talking about now with the chiefs and everything. And because the Child Justice Act is a new law, that's where we are also sensitizing them to say that if children are committing offenses, we need to bring them to book so that we can deal them in terms of the Children's Child Justice Act. Because what will happen when the children are committing offenses, in some areas they are still being beaten up, so we're trying to sensitize them. So there is something that we're doing through that particular project. And also what we usually offer those chiefs, we offer them training so that they can be trained, they can understand these issues, they can understand when the crime is committed and when the crime is not committed. They can also understand when to refer a matter, when the matter is of a serious nature. So there is something that we are doing through that project in Ndabezitha. It's where the kings, and we talk with the kings what should happen with these cases and so forth.
Thank you so much for your cards. Sisimbalu, did you note Ashley from Eldorado Park's question there? Please note that. We're going to come back to you. You want to add something there, Pratima?
Yes, I think what I need to add is, and I'm very grateful to my colleague Vuyo Mashlanga mentioning these things. The issue of the Child Justice Act versus the traditional leaders or anything like that. I think one of the big things to remember is that we want to promote the spirit of Ubuntu through the Child Justice Act, which also means that we need to foster the child's sense of dignity and worth. So slapping around a child is not going to work, not going to do it. First of all, corporal punish is outlawed in our country. And we feel that in terms of the values that underpin the Constitution, to beat a child because of an offence is committed, it's not going to assist the child.
But is it corporal punishment at schools or at home? Or is it both?
In all way, or in any way where corporal punishment is meted out, and it's not parental admonishment or so on, has been outlawed. So we need to understand that. And as the chief, I'm not allowed to corporally punish somebody else's child also. So we need to understand
So
that.
is it right if it's a parent?
A parent, even there, the right is limited. You can't take your child and beat your child senseless because you think you're the parent and you can go. Corporal punishment is outlawed.
Okay, I'm not going to do that. I'll get some gloves, boxing gloves. No, I'm just joking. I'm seriously just joking. Just now I'm going to get handcuffed.
Yes.
Vuyo, we're coming to you now. Hold on.
Actually, the issue that Ashley was indicating, yes, the right to education is actually included very specifically in the Child Justice Act because it's a developmental issue. The whole idea is the child should be provided with the opportunity to develop skills, don't interrupt their life, actually build them positively.
Correct.
As opposed to punish them.
Would we be able to read out? Is it something that could be read out this evening? Is it available? Can we jump into? I can give you some time to.
Yes, I think that.
Let me give you some time just to peruse through your documents and we're going to read it out word for word so they understand what it's saying. Vuyo.
Ingaba zeziphi izinto abazenzayo to try to make izinto zibe visible ebantwini. Umbuzo wesithathu ndiyafuna ubuza ke ngoku kula mbuzo khona umbuzo ebebuzwe ngutata I think usisi okanye ngutata ne but I'm not sure but uyabuza la mbuzo ukuba ingaba i-act lena njengabantwana bebethwa mhlawumbi corporal punishment ingaba ezo nto ziyatshintsha na but now ndifuna ubuza mna ingaba ke ngoku i-Child Justice Act lena izama iyayiguqula kwesini na indlela apho abesithi umntana nxa emoshile endlini abethwe. Ndifuna nje ubuza lona ingaba iyayiguqula naloo nto okanye yenza ngoluphi na uhlobo. Mamele Unique.
Mamela Vuyo, I've missed out on your first question. Are you gone?
My first question.
What was your first question?
Oh, my first question is, does the department have their own youth programs to help these kids that are addicted?
Okay, it's coming back to that, and I think we need to clarify that. Thank you so much, Vuyo. I appreciate it. I appreciate your three questions there. The first one being youth programs to help the addicted children coming out of rehab or going into rehab, or giving them information about what they're doing and how harmful it could be in their lives. Second question being visibility in the rural areas. And the third question I think is the encouragement of okay, that one I'm not really clear about, Vuya, but I think it really had to do something with at-home corporal punishment, which is something that we're dealing with right now. And you're going to be reading out from the Act, just briefly what it says. And then, Simbali, is there something that you would like to add? If there is something that you would like to add, we'll jump straight to you now. Sis Vuya, is there something that you would like to say at this point in time?
There's this question that has come up, but I did not get it clear whether the issue about corporal punishment is child justice trying to do something about it. If you can repeat that question for me, because I think I might answer that one, but I'm not sure what was the question exactly about the Children's Child Justice Act and corporal punishment.
Sis Vuya, I think what from a parent's point of view, really, I think parents are getting to a stage where they're worried that power is taken away from them to discipline their children. And I think what the caller was necessarily saying there was the fact that is there any provision for parents really to still have some form of control and power over the discipline to their child, because they feel that power has been taken away from them since corporal punishment was done away with, if I'm not mistaken. That could be the reason. Says Vuya, I'm going to ask you to answer that, and then we're going to. So we're gonna go to you, Pratima. We'll jump to you, Sis Mbali. Sis Vuya will come back after that one. Do we have a caller on the line? Not at the moment. Okay, let's do likewise. Jump in there, Pratima.
Thanks, Karabo. I think the issue of whether children have a right to education and what it is and which part of the Act actually would look at that. I think part where I would go to is around the sentencing. Remember, the whole aim of the Child Justice Act is to continue developing this child. Mm-hmm. Once the child has been dealt with in terms of all the diversions and the programs, or whether the child gets sentenced, the issue of education is a basic right. The child is entitled to have education. So whether the child is going to be sentenced to prison or to the Child and Youth Care Center or to a compulsory schooling program, the child must have access to education. What that actually means is that places like prisons have to actually then collaborate with the Department of Education to provide that basic right. So you'll see that in the Act, for instance, it says at section 69, one of the objectives of the sentencing is to promote the reintegration of that child into the family and community, which for me would also mean that to assist this child to become and develop into that full human being that he has or she has the potential for. So I would look at, for instance, if we were going to be sentencing a young person who's 16 years old, we would look at issues such as where the child was going to be held, what the programs are, which is something that the magistrate will also take into account, what the programs are that are on offer there, what would be the issues around a family visiting him and him interacting with other children and so on. And I think this links a little bit to the issue that was a question by, I think it was Neville from Bloemfontein, who spoke about the issue of children being placed in secure care facilities and placing other children in danger, possibly by their behavior or bullying or so. I think the issue is that at the time when the magistrate considers that form of sentence, the report from the probation officer as to what this child will require has to be tendered in such a way so that the magistrate can utilize that information, and then also have a report from the secure care facilities administrator to say, this is the program we offer, this is the kind of facility we have. We don't have, for instance, separate facilities for the child who's going to be admitted, who might place these children at risk there. all those are factors that will be taken into account when the magistrate does make the order. I think where the child does not meet those standards of behavior, that administrator has an opportunity to report back to court to say this child is proving to be a risk at this place, and the magistrate would ask for a report and reconsider those options. So I think it's not as though if a child's put once into a center that's the end of the story. There are constant reports that are tendered to court to inform the court as to what that placement has done for the child. So I think we need to and I hope that will answer Neville's question in that regard.
There we go. And we're talking, those big words are coming up again. And before we close off the show, I'd like us to just explain those words to those people who don't understand. We're talking about words like diversion programs. We're talking about words like assessment reports and schedules. Schedule 1 to 5?
The ones that pertain to the actual offence is 1 to 3.
Okay.
But there are 5 schedules in the Act itself.
We're going to be definitely tackling those issues. Don't go away. Mabatu from Northern Cape, hold on a bit for me. Just give me about 30 seconds. I'd just like to jump to Sisimbali. Is there something that you would like to highlight, Sisimbali?
No, just 2 quick things. The one thing is the addiction thing. Department of Health, the mental health aspects of Department of Health would have information on how to access would have information on how you can access rehabilitation, treatment and rehabilitation services from communities. I am not aware that any specific Department of Health facility actually provides itself that rehabilitation in clinics. But I may be mistaken. I do know that organizations like your Sanka and other rehabilitation groups. So that then becomes something that the magistrate would need to take into account when he's making an order of rehabilitation. Let us assume, that he then has to make that order. But could I just go back a bit to other issues that may not be directly within the Child Justice Act? There is a general victim empowerment program, but this act deals more specifically with really the focus on the offender. And we prefer to keep, when dealing with these issues immediately, you would then keep your offender issues and their treatment with the victim empowerment treatment a little separately until you have to have them having their mediation at the very last stage. But when you first come into contact with them,
you keep them separately.
Yes, and the victim empowerment program, just generally deals with that, treating victims with respect, dignity, finding out what their needs are, and so on and so forth.
Sis Vuyo, guys.
Yes, I'm still here.
Would you like to add something on that before we take a caller from Northern Cape?
No, what I want to stress here is the question about right to education, whether the children are not disturbed or are we not interfering with their education and so forth. When you look at the objectives of diversion, they clearly state there that when we are referring to these children for diversion, we need to make sure that we impart skills. We need to make sure that we don't interrupt their education processes. Therefore, when we are going to refer a child for diversion, we need to consider all those circumstances. If, for example, a child now who's doing grade 12 has committed an offense, when we look at that, we will look at the factors that this child is writing exams. So which program will be suitable for this child so that we don't interrupt the schooling of this child? So I think the issue of education is addressed very thorough in the Child Justice Act. Because if you look in the olden days, what will happen when the child is being diverted? The child will be diverted in court, but outside the court will be saying to children, wash the cars, wash the magistrate cars, wash the police cars. That's what was happening. But the Child Justice Act now has thought about those things. What is happening with these children? Are we imparting skills? Are we giving them skills so that they can be accountable of what they have done. So when you look at the objectives of diversion in the Act, they deal with the issue of education in an extended way. And when we're looking at the Child Justice Act, we don't need to look at it in an isolated way. We also need to look at the provisions of the Constitution, because the Constitution says that every child has a right to education, and every child, when we're dealing with a child, the rights of those children are paramount. So immediately when we are dealing with a child in terms of the Child Justice Act, you think about the Constitution to say that I need to look at the rights of children. Yeah, the child has a right to education. So for me, I don't think it's a worry factor, the issue of education. We look at those issues. And what I like about this piece of legislation, it also gives an opportunity to a child who has committed a serious offense in terms of Schedule 3 to say that this child can be still diverted. We don't have to close doors because the child has committed a serious offense. But the measures that have been put in terms of the serious offenses is that not any prosecutor can divert a serious offense matter, but a director of public prosecution can give authorization. So you can see that even if a child has committed a very serious offense, we still give an opportunity. But we are also mindful of the objectives of the diversion program in terms of the Act and also the Constitution, because in every matter that deals with a child, you need to know that the rights of children are paramount. So you cannot do anything that is against the Constitution in this regard. So for me, I don't think the issue of education is worrisome. We do consider that particular aspect.
13 minutes just before 8 o'clock. Don't be left out. 0800 142 446. All the way from Northern Cape. Mabatu, good evening to you.
From Northern Cape.
Mabatu, ke tlo kopa kwale radio ya hao.
Ke kwadile rra.
Ke a leboha mme. Potso ga o re. Potso ga o re mme wa ka.
Hello.
Potso ga o re mme.
Ke phone akile from the rural Northern Cape, mo Kurumane. And ke ready from Kurara FM. Ke itumelela ditlhaloso tsa bo Vuyokazi gore the stakeholder tsotlhe tse le gore ba ntse ba di bua, the South African Police Services, the NPA, or Department of Health and Social Development are part of the processes tse leng gore ba di dira bone di programe tsewa tsa tse ba ntse ba di bua. Mara ga re bone dilo tsewa sentle di diragala. On the health calendar of events, ke itse gore go na le awareness campaign e tshwantseng e diragale throughout ka June by intensify the campaign on mental illness, on drug and alcohol, specifically focusing on young people. Mara problem ya ka ke gore ke ntse ke utlwa a bua gore ba targetile dikgosi. Ga ba targete batho ba e leng gore simple ba ba emela ba offender e le gone ba ba thusa. E ba kala gore ke underline gore ba ba emela ba offender ke ka gore ga ba bui le bone batho ba e leng gore simple ke bone ba tshwantseng ba ba thusa. In the Northern Cape, Kimberley, recently, over this weekend, go diragetse tiragalo e nngwe e leng gore bana ba babedi mapodisi a banetse dintšha di a baloma only because ba offended. So ke worry ya ka ke gore a di stakeholders tse tsotlhe tse leng gore South African Police Services is part of them. Ba aware gore go tshwanetse go diragale eng ga e le gore go tshwara ngwana a dirile phoso a o monela dintšha our montaya. In that case, batsadi bawa ba tshwanetse gore ba dire eng ke ba dile mo koranteng rra.
Ke leboha.
Hello.
Tswela pele mme wa ka.
Ke potso ya ka e wa gore batsadi bawa ba bana bawa ba tshwanetse gore ba diragale eng. A mapodisi ba itse gore a ha ba tshwara bana ba tshwanetse ba tlhalosetse hela ya ka mogolo mongwe le mongwe gore sengwe le sengwe se o se buang se tla dirisiwa kgatlhanong le wena go court. Or ba ba tshwara hela ka gore ke bana ba ba pressurize gore ba ntshe di statement ba le under age e le gore batsadi ba bana bawa ga ba hanoga. Issue ya di social worker mo Northern Cape ke gore social workers ba complaina gore ga ba patale overtime. So o kreya bana ga ba tshwere go ditoronkong specifically ko Kimberley bana o kreya ba dula letsatsi go ya a mabedi because the social worker di thata go bonwa rra ba re ga ba patale overtime ga ba thusi bana ga ba bitse batsadi ba bana ga le policy le tshwereng ngwana e se le policy le leng gore le na le tlhaloganye maybe ke le policy la mosadi le ukwela ngwana bokgoko le batla go itse gore motsadi wa ngwana ke mang le phone le motsadi yoa go batla go itse gore a motsadi wa ngwana wa itse gore ka nako yewa bana ba ka di stakeholders tse tsotlhe tse dintsi di balwa a ba itse maikarabelo a bone mo baneng a bone ba letetse bana ba offender e be le gone ba tlang batla go thusa bana ba gaetsho. The issue ya awareness campaigns, it's very important. Let us not target batho ba ileng gore ba go godimo a re target basha ba rona ba ileng gore ke bone sentle ba dirang dilo tse gape kganyengwe ke di psychologist for Department of Education gore ba detecta problem ko sekolong gore ngwana o na le mathata ke re ngwana wa reporting ngwana yo o na le mathata process e ba e tsayang ke eng a ba involve di social worker ka gontle a ba kwalla di report go ba bolela gore go na le ngwana ko sekolong sele o na le mathata a rileng re mo thusa jang ga re mo emele a dira phoso e be le gone re ka mo thusang a re preventing before re ka ba emela ba dira diphoso ke a lebogarra
ke a leboga mme wa ka ke a leboga le ka keletso tse o bile le tsona le gore o nkile nako gore o re leletse mo diphaposing tsa rena tsa kgaso ke a leboga ke leboga le Kurara FM gore ba nkile kgaso ya rena ya bosigeng jwa ka tseno re tla be re boe re arabe dipotso tsa gago tse o nang le tsona ke kopa gore pele ga mo re ke re ye ko Rosetta from Uppington jy gaan saam met ons praat Rosetta.
Baie dankie Karabo, hoe gaan dit vanaand?
Dit gaan regtig baie goed. As ons u kan nie verstaan nie, ek sal vir u vra om in Engels te praat, maar gaan voort met Afrikaans.
Dankie Karabo. Ek wil net graag weet, wat is die maksimum vonnis wat opgelê word vir 'n jeugdige oortreder? Dit is onder 18 jaar en hoekom? Dan die tweede vraagie is, wat gebeur wanneer 'n jeugdige oortreder nou meer as een keer gevang word vir 'n misdaad?
Ek sê vir jou dankie hoor.
Baie dankie Karabo.
A more than once offender who's underage, what happens to them? So the questions asked by Rosetta all the way from Uppington. And thank you so much for even taking some time to ask those questions. Then 8 minutes before 8 o'clock, time flies. And yes, we haven't even dealt with
so much to discuss.
I tell you what, I think from here forth, can we just sum up all the responses that we have, because it's very important for me to go into the some of those definitions that people can understand them. We're going to be talking diversion programs, assessment reports, preliminary inquiries, and that much. We're going to be dealing about them. But here's two important questions that were sent by Mabatu. And the first one being, do all the stakeholders understand the procedures? For instance, the police, while apprehending the offender, do they read their rights? Do they actually follow procedure as it's supposed to be followed?
Well, could I just say, in a perfect world, we would love it to be so.
Yeah, true.
But, unfortunately, currently, we can't say all our members do. We know that some do. We have been training. We have 198,000 members of the police service. And as just one of the service providers, on a gradual basis, bit by bit, we're trying to cover the training. We have communicated to all stations what they need to do. We've sent it through the intranet of the SAPS. We've asked people to place station orders. We're trying as much as we can. Mm-hmm. We agree. Yes, we could do better with people being aware of what they need to do, and also the members of the public being also aware about what this is, that we can improve on. Right now, it's not perfect, but we're trying as best as we can.
If I may add to that, I think the Act, everyone needs to remember the Act has only been in effect for 2 years. And in those 2 years, what has happened is that all the sectors who are involved in this process have had to also develop procedures and directives and national instructions to basically direct how their members must work with the child in the Child Justice Act. And those are very important documents. Those issues actually guide all of us to know what it is that when a child comes into conflict with the law, how we need to react. So the one thing I've picked up very strongly from the calls that have come is the issue of public awareness. And it appears to me that we need to do a whole lot more, especially in the rural areas.
Yeah.
So yes, we are not perfect. We are working towards it, but the act is there, and everything that happens has to happen in terms of the process of the Child Justice Act.
5 minutes before 8 o'clock. Time flies, really. I still want us to tackle, even if it's one or two of those explanations. But before we do that, from Elders is Ms. Jacqueline.
Jacqueline speaking.
How are you doing? What is your question?
I'm fine. I would like to get into your conversation. I'm actually against this thing of children doing things that are wrong, and then you find out they've been set free under the parent supervision. I think like the area of us in Colorado Park, crime is getting worse every day, and it's done by the youth. And the drugs is getting so much, it's done by the youth. Because every time when a child gets caught up by the community workers, the patrollers, or information-wise, they've been set free and said the parents will take consent of the child to become better or doing funny things. But you find out it gets worse when you're out there. So I would like to say the corporal punishment must come back. The government must bring it back. Or else if they can't bring it back, they must build centers for this youth, the children of tomorrow, so that they can go and stay into the centers until they get their punishment after what they've done in the crime sector.
Jacqueline?
Because I think things are getting worse. Things are getting very worse. The government has to consider that.
Yeah.
And the police sector has to consider that.
Jacqueline, what is the consensus amongst parents in El Dorado Park? Are they feeling the same, that corporal punishment must come back, taking into consideration just the amount of crime that's in your area?
I think the corporal punishments come back because of things are getting worse. We find our youth, they are doing drugs openly here in the streets. They don't even respect any elders. They don't see to the people that are in the community trying to get them at the right position. They lose respect. So I think the only thing that the government and the police forum sector, they must sit together and do something about our country, because I can see our country has been damaged a lot. Let them not build extra houses for themselves and extend whatever they're doing. Let them do the right things, fix their future of tomorrow. They are the leaders of tomorrow. We are sitting with leaders that has been damaged and keep on saying the drugs issue, the crime issue. But what are we doing about it? Let the corporal punishment come back, or else let there be trust funds coming back from all over the country for us to build some centers where we're going to teach the children to have skills and education, and then give them their punishment when they come to a certain age. Let them do their trial. That's how they're going to learn, I think.
Thank you so much for your call. I really appreciate it, and enjoy the rest of your evening. We've only got a minute to go, and I doubt we're going to jump into those explanations, but maybe we can just deal with the one. But with corporal punishment being back, Mrs. Mbali, I see you shaking your head, and I can understand why, because the Children's Act simply ends against that. But what is your take on what just the lady just mentioned now?
I think, I can feel for the lady who may not really understand what's happening when you see somebody, the child in the parents' care. What happens here is this. For the child whose parent can be tracked and who actually isn't a flight risk and all those issues, they are released. And again, I'm going back to what Pritima said earlier. Depending on what you have done, then, things are also weighed and measured and scaled in terms of that. Then whilst you are still awaiting the finalization of your issue, it doesn't mean that when you are going back home and the children, the parent is taking care of you, then your matter has been finalized. No. What it simply means is, rather than putting you in a jail
prison,
with wizened criminals, you are then left under the supervision of the parent. Failing which, you then go to a secure care center, whilst you also await the outcome of your specific issue. And believe me, the rehabilitation programs and other issues are supposed to change your behavior and deal with the issue very strictly.
Mabatu, your last person we're going to be chatting
Still
to.
2 minutes left.
We've actually got like 15 seconds left. Mabatu, what is your question?
Yes, there's a question that I asked. The issue of the police officials on Friday night, the story I read on today's newspaper who released docs on 3 young people who alleged on a certain crime. What is it that those parents can do to actually put those police to book? Because I think if all stakeholders are involved, if all stakeholders understand what needs to be done if a young person is found offended.
Yeah, Mabatu, thank you so much. I think I get it. Thank you so much for that. We're just running out of time. Parents' reaction to police brutality on their kids, how can they react shortly?
Shortly, go to whoever is in charge. When I'm not satisfied with what I get from Wimpy, who do I go to? The manager. Go to the station commander, complain there. The immediate person who can sort the issue out and solve your problem.
I'm asking for 1 minute of your time quickly. Pritima, contact details. We don't got to go into those explanations anymore. This program will follow tomorrow. I'll give you times now quickly, but contact details. If somebody wants to give you a call, website addresses, email addresses.
My landline at the Department of Justice is 012-357-8205, and my email address is capital P and surname Osman, OSMAN, @justice.gov.za.
And then Sisambali, yours? Contact details? Give us an email address.
Contact details. I would prefer if people need to complain.
Yeah.
I have provincial details here that they can always complain to. Eastern Cape is 040-608-8413. These are the provincial commissioners' offices. They'll direct you. Northern Cape is 053-839-2847. Western Cape is 021-417-7148. KwaZulu Natal is 031-325-4825. Free State is 051-507-6814. Gauteng is 011-274-7875.
Time is 2 minutes after 8 o'clock. Thank you so much to all you ladies for having taken some time to be with us. Sis Vuyo, thank you so much for hanging on to the line for so long. We really appreciate making time, and all the best. We understand that there is something that you're dealing with, and our prayers are with you. Thank you so much for that.
Thank you very much.
There we go. And thank you so much, ladies. Pratima, thank you so much. Sisimbali, thank you so much. All right, if you're a listener, you would like to listen to this broadcast, it's going to be happening again tomorrow. Eastern Cape, please tune in at 5 o'clock. It'll run for an hour up until 6 o'clock. If you're going to be in the Western Cape, it will be running from 6:15, running all the way up until 7:15. In the Free State, it's going to be happening between 7:30 and 8:30. So please note those times. We will definitely continue with this broadcast, so make sure that you catch it then. Hey, before we go, children, what are they saying? Let's play out with a clip from one of the kids from the street, living on the street, and let's check out what they're saying. From myself, Karabalats, that's it.
Anything you want to say before we go?
My name is Piwe Chulu. I'm living at Harankuwa. So people about to let them more couple my advice. Kiwari, Cecilinte Molfatimo. Kinaka regret who so Kaufela Runa. My
name is Godfrey, and my advice to the teenagers is that Korbasali peer pressure, Batomabazana Mara drugs, Korbazana Mara Matata, we don't indeed as the Vakasi survive. So stay away from drugs.
My name is Moses Marulega, and Namamelodi. So Nanga Tavelo Lore. Machita ba utlweletseng go ntle kwa ba fetu rena re tsentse ka mara di drugs ra pallwa ne tano nya ga thuso le ne tlist le utlweletse bana le sabela le ka o tsenella mo di drugseng into e kotsi di brats.
My name is Justice Matawe. I stay in Harankuwa. My advice is gore bana ba banyane ba tshwantse le sekolong, we are in danger place, tshwantse ba lebelle ka rona.
Oh, there we go. Those are some of the words from the guys that are living on the streets at the moment. So next time when we see them, let their approach be of help and not that of judgment. That's my last word from myself, Karabalans, until we meet again next time.